Mr. Needler, wasn't the a goal of the California regulations to reduce the use of petitioner's fuel?
Certainly in 2013, when it was adopted, and I think this is an important point, in 2013, where the fuel producers were already selling in the market, it would have been, I think, quite easy to show that their injury derived from this new regulation. It was caused by that regulation, and it would be redressed by lifting it. It's now 10 years later, though, that manufacturers and no one else challenged the waiver in 2013. In the meantime, there has been 10 years of practical experience in which manufacturers have adjusted and quite without regard or without resting upon the California rule.
But when EPA reinstated the rule in 2022, was it intended to do nothing at all?
No, not at all. I think on that point, I think it's important to understand the legal rationale or the legal analysis that EPA brought to bear. And this is something on which there has been changes from one administration to the next, and that's under review. But a waiver in the approach that EPA was taking is for the entire California program, not just these two particular standards. So a waiver is for the entire program, and if the entire program is necessary to address compelling and extraordinary circumstances, that's sufficient. But another important point is that
in 2022, didn't the EPA, in fact, in its submissions to the courts, say that the effect of the reinstatement was going to be to reduce gasoline emissions?
They said that in 2021, based, frankly, I think on 2019 projections. A lot happened especially in the zero-emission vehicle market.
So we shouldn't take the EPA's own representation seriously?
Oh, it's California.
I think both EPA and California made those representations in its papers.
Well, yes, but was that sufficient? The evidence, as you said, is pretty thin, and it's also important to recognize what the.
If it was so thin, I don't think that you had a grounds to reinstate the waiver.
Well,
and if it's so thin, why did you say what you say in your briefs, and why did California say what it said in its briefs? Because both parties, I think, said in their briefs, yes, this is going to reduce gasoline emissions.
Well. What EPA did, the principal reason that it did what it did in 2022 was because it concluded that the withdrawal of the previous waiver was unlawful. It was correcting an error before. It was not a new waiver. What EPA did was conclude that what it had done in 2019 was unlawful for a variety of reasons. It rested on an erroneous interpretation of the statute, the one that I was just mentioning to you about, do you look at the whole program or do you look at particular standards? So they were going back without making a brand new assessment. And that's why I think it's important to recognize that between 2013, there's no doubt that in 2013 that fuel producers were injured and that would have been redressed by rescinding the rule. But that's not the case now because the manufacturers have adjusted and the market now reflects the fact that there's no particular reason to assume, or at least there is objective evidence contradicting the proposition that the manufacturers would change their behavior in a material way.
The California interveners said that California's regulation would mitigate competitive disadvantage by ensuring, quote, a level playing field, close quote, for manufacturers who wanted to produce more fuel-efficient vehicles. I just don't see how that statement alone doesn't destroy everything you're arguing. Meaning, what it's doing is mitigating a competitive level or supporting a competitive system, isn't that a negative effect on them?
Let me make one other point because I think it's responsive to that, and that is that the D.C. Circuit was relying on both FRAP and the local Rule 28 that addresses how standing, an assertion of standing should be raised on a direct petition for review. It has to be raised in the petition, in the opening brief with any supporting materials. The only thing that was submitted here were the 14 declarations that, in a conclusory manner, said that their injuries would be petitioners here, their injuries would be ameliorated if.
But now we have a full record.
Well,
and
but
let's
but
address Mr. Wall's concern, which is if we reverse for the D.C. Circuit to look at this again, vacate and remand only, correcting their 2025 ending date misperception. Are you saying that we should not just say they have standing on what we have before us now?
No, I think if the court is uncertain, it should vacate.
No, if we're not uncertain.
Well, but what you have here is effectively a summary judgment ruling in favor of EPA. If you think that there are disputed issues of fact going to the question of what the effect of the reinstatement was, then just like any other situation, it should go to the trier of fact to determine what the effect would be. There should not, otherwise you're effectively relying on the categorical rule or prediction that we think is wrong. We agree that it should be fact-based.
Sorry to interrupt.